Welcome everybody to another spectacular program and meeting of the Northwest Business Club. The Board of the Northwest Business Club is happy to bring to you today the managing attorney for the Pacific Northwest region of the Pacific Legal Foundation. Okay, he has been in this position for about 8 years. Prior to his position, he worked for the Washington State Attorney General's office about 5 years. His primary position, his primary passion is the protection of individual property rights. And as many of you know, he just recently was on the winning team that won the largest property rights case in recent history at the U.S. Supreme Court level. Kind of a heavy hitter, this guy. Anyway, so let's put our hands together and welcome Mr. Brian Hodges, who's today's speaker.
Hi, thank you for having me. Let me just begin briefly by telling you all, many of you know Pacific Legal Foundation, but for those who don't, Pacific Legal Foundation is one of the nation's oldest nonprofit legal foundations. We were established about 40 years ago. Our Pacific Northwest office was established 20 years ago. We are dedicated to fighting for private property rights, individual rights, against government overreach, areas of economic liberty, etc. The case I'm going to talk about today requires a little bit of background, and the background is actually very interwoven with Pacific Legal Foundation's existence. The case that I'm going to talk about today is Koontz v. St. John River Water Management District. I'll just call it the district because that's a lot of words to try to speak again and again. But to begin with, you know what's one of the best ways always to find out whether you've done good? Is to look at what your critics are saying. See just how angry they get. So let's just start off. I'm going to tell you the Butler did it. We won. What were the first words that opponents of property rights said when this case was decided by the Supreme Court in June? Well, a prominent professor out of Vermont immediately wrote a paper calling it the very worst takings decision ever. And you know, he's criticized a lot of takings decisions, so that says something. Justice Kagan, who wrote the dissent in Koontz, said that the court would rue the day that it issued this opinion and predicted that protecting private property could wreck land use planning across the nation. It was called revolutionary. Now I'm going to ask you all to keep that word in your head throughout this presentation, because we're going to come back to it and ask the question at the end, or answer the question, what is so revolutionary about this case? Well, in order to really understand what we were arguing to the Supreme Court, we have to go back in time a little bit to this case, Nolan v. California Coastal Commission. This was one of Pacific Legal Foundation's first U.S. Supreme Court victories. We fought this case back in the mid-'80s, got the decision in '87. This had to do with the Nolans, who bought this small 500 square foot bungalow right on the California coast. Subject to, it was a dilapidated cabin, and they were required to tear it down and rebuild it in order to purchase the property. So they submit a permit with the Coastal Commission, which is the agency in charge of issuing permits along the California coast. All they asked for was to build a house that was virtually identical to all of the homes to the north, to the south. Well, the Coastal Commission came back and said, well, we'll let you build your house, but only if you give us something in return. We want your beach. Now, this is, what they asked for was, okay, that's the Nolan's house. That's actually the house that they rebuilt there. So there was a little tiny shack in the middle of all of these homes. The Coastal Commission demanded this strip of land along their beach, cutting off the Nolans' right, their property, by being beachfront property owners, they had the right to access to the water. The idea was that the Coastal Commission wanted to have an undisturbed path from one park, the Cove, up to Faria County Park. And they were going to create that path, not by buying this land. And let me remind you, what does the Fifth Amendment say? Thou, government, shall not take private property without due process and payment of just compensation. Just compensation. What they were trying to do is get around that requirement for just compensation by waiting for the opportunity for each of these people to, the Nolans build a new house, perhaps the Smiths here want a new deck, perhaps these guys want to put, looks like solar panels, perhaps they wanted solar panels. They take that opportunity when the government has control over your right to use your property to say, sure, you can do what you want with your property, but you gotta give us something. Well, PLF took that case up to the US Supreme Court and established this constitutional standard that's called the essential nexus test. What it means is that there has to be some actual connection between an impact of the development and the demand that's being made by the government in order for a permit condition to be constitutional. Let me make that a little clearer by looking at what was demanded in the Nolans case. The Coastal Commission said, justified its demand for that easement by saying that this row of houses is psychologically harmful to people who drive up and down this highway. Drive this highway with the idea that they have a connection to the coast. Therefore, they should be allowed to see the coast. Well, Justice Scalia looked at the purported justification and said, whoa, that doesn't make any sense. Nothing about that easement is going to help people in the cars see the water. What you're really doing is nothing more than an out-and-out plan of extortion. You're trying to get in between the Nolans and their right to just compensation. If you came up to their door, knocked on the door and said, hey, we're taking your beachfront, you would have to pay. The fact that they have to ask you for permission to use their property doesn't change that fact. There's no nexus, then this demand is unconstitutional and invalid. Okay, so that was seen as a revolutionary decision, but very quickly, planners figured out a way around it. It's really not hard to find a nexus, is it? I mean, even Justice Scalia said in his opinion that had they demanded perhaps a strip of property here or a little viewpoint where somebody could pull over in their car and look at the water, that might have been sufficient to establish a nexus. It's not hard. Well, we fast forward a couple of years to another case that PLF was involved in taking up to the Supreme Court. We were an amicus in this case, out of Oregon. Dolan v. City of Tigard. In this case, the widow Dolan owns the A-Boy hardware store, submitted a permit with the city asking to renovate her hardware store, and part of that was expand the parking lot to allow for more customers. The city came back and said, sure, we'll let you do that, but we have two conditions. One is that you dedicate what they call a public greenway, what we call now a buffer around the stream that ran, actually it's right underneath, next to the hardware store, and a bicycle path. Well, this case made it up through the courts, all the way up to the Supreme Court, and the problem with this case was, there was arguably a nexus. I mean, it may seem a little attenuated, but sure, she's increasing the number of parking stalls, increasing the size of the store. You would hope that as a business, that it would be increasing traffic, will therefore mitigate traffic demand bicycles. There's your nexus. Increasing the size of the parking lot is going to increase storm water flow. perhaps burden the stream, increase flow into the stream buffer. There's a nexus. Well, this, again, made it up to the US Supreme Court with this idea, the question, is nexus enough to protect the right of a property owner to seek just compensation if their land is being demanded for a public purpose? Again, in this case, if the government had just come to their door and said, Ms. Dolan, we want the front of your property for a bike path and a buffer, it would have to pay. But by couching it in, we will give you the right to renovate your property and expand your parking lot if you dedicate these property interests to us. Does that get it around the requirement to pay just compensation? The US Supreme Court again said no, but it wasn't just because of essential nexus, it was because of the second concept, rough proportionality. So you have connected the dots between an impact of the property and something that the public, something that would mitigate the impact. Let's just talk about the bicycle path. You've shown that there's an increase of traffic and that providing bicycle path would somehow mitigate traffic. You can't just rely on that, that's not enough. So the court developed this rough proportionality test that basically asks, okay, so it's related, but is it close enough? Is it proportional? This development is adding parking slots. What in the world do bicycles have to do with that? Same thing with the stormwater, with the buffer. You want this property, but you haven't shown us that it's necessary, that all of the land that you've put into the buffer is necessary to mitigate for the little increase in stormwater caused by your new development. The generalized connections that are shown by the nexus inquiry are just too lax to protect the fundamental right to just compensation. Here's a picture of that's the buffer and that's the bicycle, the bicycle trail. And just as a little coda there, the city did get that property, but at the end of the day, when they first made the demand, it would have cost them approximately $30,000 to purchase the buffer and the bicycle path.
Who's now?
I'm sorry, the city of Tigard. Good. If I do that, ask the question, because I'd rather be specific than leave it hanging. After the case went up to the U.S. Supreme Court, came back, do you know how much those buffers, or the trail and the buffer cost the city? Keep going, keep going. Do I hear 1.6 million? Yeah, there's a lesson in that, but that's a lesson for a different presentation. Anyway, we have these nexus and proportionality principles that every land use attorney, every planner understands. But there were a couple of questions that over the 25 years since Nolan and Dolan arose, and really there was no good solution. Courts across the country were at loggerheads about these questions. And that's, how far does this exactions test reach, the Nolan and Dolan test reach? Do they apply when the government denies a permit? So say you want to renovate your hardware store, and the government says, well, we'll let you if you give us a bike path, a buffer, et cetera, et cetera. And then you say, well, I can't do that because I don't think that the impacts of my new hardware store support those demands. And the government says, fine, denied. Well, there was no condition, was there? No property changed hands, not like the Dolans who, even though they won and they had those permit conditions invalidated, the buffer's in the government's hands and the bike trail's in the government's hands. No harm, no foul. That's what some courts were saying. And what if they said, well, we want a bike trail, but why don't you just give us the $25,000, $30,000, and we'll buy it from the guy across the street? Sound like a deal? No real property changed hands. Does the Fifth Amendment apply if if the government says, sure, you can do this development, but only if you pay a mitigation fee or an impact fee? Well, those questions, like I said, led to split decisions across the nation. And one of them is this case Koontz that came out of Florida. Now, you might wonder what a Pacific Northwest attorney was doing trying a case out of Florida. Well, these issues, I've been fighting these issues in Washington, and when we saw this case arise out of Florida, we jumped on it and said, this is the opportunity to have this split finally addressed by the US Supreme Court, which we've been trying to do for years, because it wasn't advancing anyone's interest, whether you're on the planning side or whether you're on the property owner's side, to have no answer to these questions. So the Koontz case. Coy Koontz, in 1972, Coy Koontz purchases a 15-acre lot of undeveloped commercial property in Orange County, Florida, that's at the intersection of two major highways. At the time he buys it, there are no regulations restricting its use. But over time, in the 1980s, Florida went through a lot of the same sort of regulatory reform that Washington did. They got a big wetlands and water management type statutes. They adopted growth management type statutes. So anyway, by the time he files his permits to start to develop this property, it's 1994, and much of his property is subject to regulation. Okay, now let's get a picture, because it's really hard to talk about property without looking at it. This is Coy Koontz's lot. I'm going to step back so that everybody can see. Right there. Intersection of two major freeways. Along this side is a drainage ditch that the Department of Transportation cut to drain this highway, effectively draining any wetlands that were on the northern portion of his property. I mean, you're way too, aren't I? Okay. Right here, high power line, easement, running through his property, bisecting the property. That area is cleared and maintained again by Department of Transportation. The top of his property was condemned and turned into a truck pullout area. Next door is development all around. He's told that this is a wetland that needs to be preserved. Well, let's look at that. What they actually said is, because this is within a boundary, a riparian zone, we will presume that this has wetlands unless you can prove that it doesn't. Well, Mr. Koontz hires an expert to support his permit application and says, okay, well, this top portion completely dewatered by government projects. There's no value to as wetland. It provides no buffers because it's completely cut off from all streams and wetlands, et cetera, et cetera. Yeah, down here there's some wetlands. So here's what I'll do. I just want to clear and grade this so I can start a commercial development. I'll give you the 11 acres at the bottom of my lot. Forever. Conservation easement, it's gone, it's yours. What do you think the district said? No. How did you guys know? Are you looking at my notes? I might be. Or have you lived this before? Yeah, they say, that's not enough. We want more. Well, what more could they ask for him? He had nothing more to give on his lot. You saw that 3.7 acres was what he needed for his commercial development. The 11 acres was all that's left. What about money? Did you think that? Yeah, okay. I saw your... Well, and this is a program that can be beneficial or it can be extortive. In this case, you know how the case turns out, so you know which way it's probably going to go. Anyway, the district says, okay, we'll take your 11 acres, we'll let you do the clear and grade on the top 3.7 acres, but only if you agree to pay to enhance and restore at least 50 acres of district-owned property located miles away in the sort of mitigation banks where you will, replace non-functioning culverts, plug and fill ditches. The district estimated that fixing one culvert would be approximately $10,000. There were so many culverts and ditches to fix that Mr. Kuntz's expert estimated $90,000 to $150,000. And let me remind you, this is $1994, back when $150,000 bought you more than a grande Starbucks. The expert report's interesting because it says, well, I told you before, the wetlands were drained. There were 0 acres of even potential wetlands. There were no critters on the property, except a raccoon, possums, 1 turtle, and hobo camps. Okay, there you go. That was what the district was trying to preserve as an environmental protection area. Well, Mr. Kuntz was aware of this, the Nolan and Dolan concept, and objected. He said, look, I've given you 11 acres. There's 0 on my property that even requires mitigation for me to use that top portion. I can't, there's nothing more for me to give. The district says, well then, you don't get a permit. And they said that the only reason that we would give you the permit exactly as you filed it, but for your refusal to pay off-site mitigation. Mr. Kuntz takes this case to court in Florida. He wins at the trial court. The trial court endorsed his expert and said there's no environmental impact for developing that top portion of his property. These sites, I couldn't even fit both of the sites on the same Google map and make it readable. This intersection up here is Mr. Kuntz's property. Down here is the wetland preserve. It's hard to see here, but this is very dense residential development with roads crisscrossing it. There's absolutely no connection between clearing and grading up here and fixing culverts, plugging ditches down here. Well, trial court says this violated Nolan and Dolan. There was no nexus because there was no impacts from his proposed development. No proportionality because, well, if there's no nexus, there can be no proportionality. Goes to the Court of Appeals, it wins. Goes up to the Florida Supreme Court, and remember a while ago when I was talking about those questions. Does this apply to a permit denial? Does this apply to money? Well, the Florida Supreme Court said no to both and said, we don't care if they made that demand. They denied your permit and it was for money, therefore you have no cause of action. You cannot seek relief from the courts. You lost. Go home and lick your wounds. That's when PLF got involved. We were actually involved during the state proceedings as an amicus, but we took over direct representation after that decision came out of the U.S. Supreme, or out of the Florida Supreme Court, and petitioned for review at the U.S. Supreme Court, arguing that, well, here's the argument that we made. You put a gun to somebody's head and you say your money or your life. They give you their money, that's a crime. If you put a gun to somebody's head and say your money or your life, and you don't get the money, it's still a crime. It doesn't matter that the money transferred hands. It doesn't matter if they say your property, your real property or your life, it's a crime. The same analysis should hold true here. If they say that that you cannot exercise your constitutional right to use your property, sure, it can be subject to reasonable regulation, we know that. But if they say that you cannot unless you give us something and waive your right to just compensation, then that is the same thing as taking property without just compensation. The U.S. Supreme Court agreed with us, I'm happy to say, in a decision that's really eye-opening. Remember the revolution word that I brought up in the very beginning. Well, on the first question, we got a 9-0 decision. Not a single justice dissented to the question that in the circumstance where the government denies a permit because you won't give in to extortion, you have a right to have that decision overturned as being unconstitutional. It's the second question where we got a split court. And this is where you got to ask yourself, is this really revolutionary? And that was the question whether the Fifth Amendment protects money. Is money property?
Yes.
Okay, I thought so. Does the Fifth Amendment limit the term private property to real estate?
No.
Okay. Well, you guys could have written the brief and argued the case. That was really the crux of the case was, does the Fifth Amendment protect property? Because this Nolan and Dolan stand for what's called the unconstitutional conditions doctrine that says that government may not condition a benefit or a permit upon a demand that you waive your constitutional right. In this case, your right to be free of a taking of money. Now, this is how heated the argument was. The government, and this should actually, this irritated me. I think it should irritate everyone. Not only did Florida try to defend that position that money isn't protected by the Fifth Amendment of the Constitution, but the federal government stepped in and sent the Solicitor General in to argue that the U.S. Constitution does not protect people's private bank accounts from appropriation by the government. And that's offensive that they took that position. Scalia found it particularly offensive. Here's a quote from the oral argument. As I understand your position, cash is magical, right? The government can come into my house, take all the cash that's there, and that's not the basis of a takings claim, right? Because cash is not a taking? Does that make any sense? Sorry for the poor Scalia imitation, but. Of course, that question pretty much told you what the implied answer is. Justice Alito, who wrote the opinion, was a bit more moderate in his addressing the situation. He explained, why do we have these Nolan and Dolan rules? Why do we say that you can't do this? You can't use the permit process as an opportunity to take property. Well, he explained, land use applicants are especially vulnerable to the type of coercion that the unconstitutional conditions doctrine prohibits, because the government often has broad discretion to deny a permit that is worth far more than the property that it would like to take. So if we were to go back to the Coons example, what if the district had only asked him for $500? The case probably would not have made it to the US Supreme Court. And that happens often, just because of this, the broad discretion that land use planners have, or the permit desk has when they issue these permits. I'm sure most people who have gotten permits have seen things that offend them, but they're not worth, especially buying an hour of one of my colleagues' times, because my colleagues charge a lot more, especially the ones in the private. We're nonprofits, so. Alito did explain, though, that does not mean that there can be no conditions on permits. That would be an error. He said that the Nolan and Dolan test, the reason why we have this nexus and proportionality is to address the two realities of the land use situation. On the one hand, you have to acknowledge that development can have external impacts. That say, paving your lot could create a stormwater problem and push that onto a neighbor's lot or push that onto a city street. And in that circumstance, the government is perfectly in its right to demand that you do something to mitigate for that. They could deny the permit, or they could say, hey, you need to take the front 25 feet and do a stormwater treatment, some stormwater treatment there. That's constitutional. But you take a circumstance where the water is coming from a street, crossing the person's lot, and then affecting someone else. They can't make you mitigate for someone else's problem, or a pre-existing problem, or make you pay for their own project, their restoration project 7 miles away. Well, over to the dissent, it's always good to see what the other side was saying, because this is the fair representation of the views of many involved in this permitting and property rights debate. Justice Kagan and the four justices that the signed onto the dissent really struggled with the idea that money is constitutionally protected. On the one hand, they said that it's not really the same as other property and probably should not get the same respect as other property. But then they were struggling with the idea of how do we protect it, because it is property. So on the one hand, it's very disjointed, but it is interesting because even those who would oppose the nexus and proportionality rules, the balancing rule, aren't sure what to do. Is it a due process violation? Is it a taking? Is it something else? They propose a whole bunch of different theories that would have gotten them around the heightened scrutiny test that Nolan and Dolan require, but never came to a conclusion. It's a problem. Justice Sotomayor, during arguments, we heard Justice Scalia talking about money, cash being magical. Justice Sotomayor was probably the most outspoken opponent of our position. And this is a quote from her, from oral argument. "I see an enormous floodgate here, and one in which we're sending the signal that perhaps states should be more quiet rather than more engaging, that they should just say no, because anything they offer is going to be seen as potentially an unconstitutional taking." Well, the answer to that is no, they shouldn't stay quiet, and they shouldn't just say no, because both statute and constitution would prohibit them from, if you go in and ask for the right to use your property, which is a constitutionally protected right, they can say no, subject to reasonable regulation. They can't just say no. They can't just do this. So that's not a solution. So this is what Kuntz established. This cause of action called an unconstitutional condition claim predicated on the takings clause. It's not the same as a direct takings claim. What this says is instead a direct takings claim would say, you took my property, you didn't pay for it, now's the time you're gonna have to pay. This, however, and let me say, that's a frustration among many property owners, that when their property gets regulated away, they lose their property. All they get is money. So many property owners just want their land. This one preserves your land. This one says that if you make this demand, if you make this unconstitutional demand, it is void. It cannot be implemented. It is in excess of the government's power because it's a violation of the Constitution. This is the key takeaway. This is probably Alito's best explanation. Extortionate demands for property in the land use permitting context run afoul of the takings clause, not because they take property, but because they impermissibly burden the right not to have property taken without just compensation. So, wrapping this up so that we can open this up to questions, comments. I just want to show you a picture. This was a Google map of that same intersection where Mr. Kuntz's property is located right before we went to court. So he applied for the permit in 1994. He was denied. This is 2013. All these little flags are businesses. That's the top portion of his property. It is still undeveloped. Over here is a gas station, there's a Chinese takeout, there's a dry cleaner, there's a chiropractor. My favorite is right over here is a doggy daycare, and if I could zoom in, right behind it is a dog bone shaped doggy pool. I love dogs, so I'm not mocking that land use, I'm just saying that the whole reason we have this undeveloped block right here of commercially zoned property is because the government was claiming that this was so environmentally sensitive that it could not be touched without a $150 payment. And yet, This area was fully developed during all the years following his lawsuit. One last picture. This is the highway passing by. That's Mr. Kuntz's lot. You can see the gas station right there, the truck pull out. Just to get an image of what is this property, what does this property look like that went all the way, took 20 years to litigate, all the way up to the US Supreme Court. And it's amazing that this modest little parcel of property was so important to the rights of individuals all the way up in Washington State. So with that, I'll conclude and open up the floor to questions.
In the questions, just remember our basic rule is members get to ask questions first. When you're called upon, stand up, state your name, and ask your question. I'll let you go ahead and choose whoever you want.
Oh, yeah, go ahead.
LA fine. Just a quick one, which is, you mentioned Kagan and Sotomayor, who were the other two that were dissenters.
Breyer and Ginsburg.
Breyer and Ginsburg, okay. And then, now that we've lost Sanders on the Washington State Supreme Court, whom do we have left as a friend of our personal property rights?
Justice Johnson is still on the court.
That's it.
I'm sad to say that actually, it's hard to tell with the current composition of the court. We know that there are some opponents, but the court has not taken a property rights case in a couple of years, in several years. I've been sending very good cases up for the Supreme Court to look at, and they just have, it has not been interesting them. So it's hard to tell which direction they will go. There was one recent case that we were involved in that involved a Department of Ecology order demanding that somebody not use a stream in which he had stock water rights for watering cattle. There was an argument that that was a taking. The taking issue was fully argued to the Supreme Court, and they sent it back to the trial court saying it hadn't been fully, it hadn't been properly presented. So
that's still in progress?
That's going back for further litigation. So we don't have an idea how the new justices will view private property rights. We know that some of the justices who've been sitting there for a while take a different view of property rights. Let's go back and then over there.
Back to the map that showed the businesses that have been developed.
Yeah.
It begs the question that over the time that this was in litigation, how those other businesses came to be, obviously they have to get a permit.
Yeah.
So it appears that there's there's a discriminatory and uneven application of the laws and the rules and the regulations on this guy, when right beside him everybody else is developing their property.
That's one of the problems. We also don't know what went into those permits. Perhaps, for example, the gas station. Perhaps there was enough investment behind it that a $90,000 mitigation fee was chump change, penciled out. So maybe they paid. Maybe the rules were applied differently because of the litigation. I mean, you've got to understand that the district was aware of what was going on.
That's the whole point.
Yeah. No, I understand that point. And that's a point of frustration to a lot of property owners, especially when you're the one who has to fight the fight, is that other people are not being burdened to the same degree.
There's a proposal right now, I mean currently this week in Whatcom County, that property owners have to prove, I don't know how they can prove, they have to prove that there will not be an impact to get a permit. How could we possibly address that they have to prove that they will not have an impact to get a permit. What kind of a loophole is that going to create?
Well, it turns the constitutional burden on its head. I don't know what the proposal actually says, so anything I say shouldn't be construed as a comment on that proposal. But placing the burden, one of the most important aspects of the Nolan and Dolan test is that it adopts a heightened scrutiny test that places the burden on the government when it is, I'm getting there, I'm going to connect the dots. When it imposes a condition on development, here it's saying that you have to prove that there's no impact before you even get a permit condition. Well, that may run into some constitutional problems, because first the government has to show a reasonable basis for the permit denial. And if it is because for a reason that you weren't able to show no impact, you may wind up in a similar situation to Coons.
Yeah, they have to prove that they're not going to impact the water situation. that their water, that they won't be using, that their land use, that their permit, by having a well and by building a house, that they're not going to do any damage to the watershed. That's the proposal. You have to prove it. And if you prove it, maybe you'll get it. It seemed always to me that the government, it's like the police power. They have to prove that you're doing the damage first. That's the nexus thing.
That's typically the way the burden works. When it comes to water that's a very regulated area of law, and without me looking at the actual regulations, I'd be afraid to comment on that, because there are circumstances where water is a matter of statutory right rather than property right, and that could change things, but I don't know the facts of that. There was a question over here in the, did you have one?
Yeah, go ahead.
Yeah, I'm just curious whether there's been any remedy to a situation. I don't know if this was one where, let's say a property owner is the county or the municipality praises the value of the property at X because it's developable, it's commercial and developable. 20 years later, through a lawsuit or whatever, they go to develop, but the county or the municipality deems it as undevelopable, but yet they've been collecting taxes on it for 20 years based on a certain value. Any rulings or remedy for that?
I don't know of any cases addressing that. I wouldn't be surprised if there was one. That is a problem, because through zoning, they can change the character of property prospectively. We've all seen that with Growth Management Act, with the urban growth area boundaries.
You're not aware of any cases that property owners have taken to try to get their
To try to reclaim tax based on a change
pay
of.
taxes based on?
I'm not aware, but that's not really an area of law that we practice in, so my lack of awareness doesn't say that there's nothing out there.
This will be a little bit of a corollary question. What you wanted, Coons, is you showed in your analogy that a gun had been put up to the side of someone's head, whether the trigger was pulled or not. Now, all of those other flags, do they then have the right to come back and say, wait a second, the gun was put to my head too? Is there an obligation to make right wrongs that are called attention to by the ruling?
You want to hear something really sad? Is in Florida, no. And that's one of the reasons why we took this case out of Florida is if you accept a permit with conditions, you are barred from challenging the conditions regardless of whether they're unlawful or not, because you accepted the benefit. So, and the reason why we took the Coons case was because he objected to the conditions before they were imposed and was denied a permit, and we said that put him in a situation where he couldn't win either way, that he was either subject to an unconstitutional, a deprivation of his constitutional rights, or a deprivation of his constitutional rights. You know, there was no getting out of that. There was no getting off of that. In other jurisdictions, Washington doesn't have that rule. Many do. California has that rule as well. Washington doesn't have that rule, but it does have statute of limitations. And so do the federal court. So if you were to bring a claim challenging the exaction, saying that that was unconstitutional, it would have to be brought within a certain number of years in order to recover anything.
How many of those have ever been successful?
In that circumstance, probably none, because, because we just got this rule that would allow them to go back and do that. So, stay tuned.
Yes.
There's a question way back in the corner.
In Washington State, they've got the Department of Ecology is enacting this where you have to, in order to get a permit to maybe do an improvement or development, you have to be able to, if you're in a rural area and you're not on a municipal water sewer, where you're going to have engineered landscaping that prevents water that flows onto your property or rains down on top of your property, like 97% of it from flowing off of your property, trying to force it down into an aquifer. Maybe it works, maybe it doesn't. Don't even know what the ramifications are going to be on this type of landscaping, whether or not after trapping and holding all of this water through evaporation, if there's going to be toxic problems there. Is this something that could potentially be relevant to Coons?
Yeah, the equation that Kuntz addresses is a permit subject to condition. So if this is a permit, an ecology permit, and it will be subject to that condition, it should be subject to the Nolan and Dolan balancing test. And I have been looking at a similar, it's a critical area regulation, but it's requiring certain property owners to dedicate buffers, not to mitigate for impacts caused by their own development, but to mitigate for stormwater runoff that's coming from the road above them. And that goes to my example when I was talking about the proportionality test and the Dolan development, that an increase in impermeable surface area is known to increase stormwater runoff. Fine. But and you can tell me that I have to mitigate for that increase in stormwater flow. But you cannot constitutionally tell me that I have to mitigate for the pollutants that are suspended in the stormwater that's coming off the street. If you want me to do that with my property, you have to purchase my property. You can't do that in a permit condition. That is one of the areas where we're hoping to see Kuntz and Nolan and Dolan applied. Yes?
Yeah, mine's Bill Canoes. I've asked a number of attorneys the same question, and I'll ask it you. And they all give me that it's a gifting of county funds. It's been a frustration of mine that in Whatcom County, we value certain development rights enough that we have a purchase of development rights program whereby we will buy development rights off property owners. The adjacent property could have got downzoned through the Growth Management Act, and they have and received no compensation whatsoever. When I've asked about setting up some sort of a mechanism that could compensate those folks for those down zones or zoning changes, I was consistently informed that that was a gifting of county funds, and we couldn't do it. It just seems discriminatory to me that we value one set enough that we're willing to buy those development rights, and then the other end of the equation is that if the county if you want to upzone a piece of property, take it out of the zoning like open space or something, you at least have to pay the past 7 years back taxes to do that. These property owners that got downzoned from commercial to residential, or got downzoned from so many development rights to one development right, were compensated zero. And whenever I bring up the question of a mechanism that we can go back and recover those development rights and compensate those landowners, I'm consistently told it's gifting. Do you have any answer to that?
Well, gifting is a theory. This idea, it was developed by Harvard lawyers in the Harvard Law Review as sort of a witty response to takings, because the idea is that if government can take, it can also gift, and that by providing you with, say, denser development rights, it is through its largesse giving you something. Well, the answer to that is that good government is supposed to improve the quality of its citizens, improve the quality of property. So, quote unquote, gifting is actually government working correctly. There are circumstances where zone changes are warranted. In the American system of property, It's really, there's sort of a perverse incentive to maximize your land use under your existing code because it could go away tomorrow. In Washington, with the Growth Management Act, with this, every 7 years we're going to redraw the lines, or we're going to, change densities, et cetera. It really puts, if you think that your land is developable, it really incentivizes people to build out as much as possible before the laws change. I don't think that that's that the people who enacted the Growth Management Act were thinking about that. You mentioned what's called the purchase of development rights. That is actually a program that, if implemented correctly, can alleviate some of these pressures that property owners are feeling from these constant changes in zoning and development thresholds. That says that if used properly, one parcel gets less development rights, but gosh, this gets really complicated. I don't know if I want to go there right now, but it is it would take me so long to get into how transfer development rights can work, can function, and there are some cities who have applied it, but it is a way of transferring benefit when one person gets a benefit from a zoning change to a person who has lost something from benefit change without, or a development change without government giving money to somebody. There was a question back there, and then we'll...
These cases typically involve a single property owner. Kuntz was lucky because the Pacific Legal Foundation found you, or you found him. What do all the other property owners do to fight these situations? They're just individual families and people who waited to retire. Now they want to put a well on their property. It used to be a hire a surveyor, you go get a permit, now you got to hire a lawyer to do it. What should people do?
That's one of the hardest questions, and that's what Justice Alito was talking about with the, oftentimes people who are applying for a permit are in the position where they're asked for a concession that's worth less than the property. They go and they look at the going rate for an attorney, a real estate attorney, and say, okay, well, whatever, I'm going to give up. Pacific Legal Foundation, we are small compared to the size of government, state, federal, local, but we are national. We take cases pro bono. We don't charge fees. We have to be very selective about the cases we take. Like I said, when we selected the Kuntz case, it was because it was all of the facts lined up so that we could set this precedent. And what we try to do is find the case that will set the precedent so that the thousands, tens of thousands, hundreds of thousands of people who are experiencing the same kind of deprivation will find some relief. Unfortunately, there aren't enough of us to represent every person.
Thank
Yeah.
A few years back, the Whatcom County required me to give up my property development rights in order to go on the sewer going in front of my house. Wouldn't this be the same sort of thing?
In order to hook up to a sewer?
Yes, that
Was
runs
it
right
on
in front of my house.
So it was on a permit?
Yes, they required me to give up property development rights on my property in order to get a sewer permit.
Yeah, that's the kind of thing that the nexus and proportionality rules should be applied to. Don't know enough facts to say which way it should have gone, up or down, but the analysis, that balancing analysis, should have been applied to it to determine whether those development rights were sufficiently related to some impact if you're hooking up, so that they could demand them. Yeah, we had a question back there.
Just real quick one. In the state of Washington, it's my understanding that most environmental law is written on the presumption that basically you are guilty until you can prove to the government you're innocent. Does this Kuntz case have any effect on that general approach in terms of...
Yes, and to restate, I can restate that as most environmental law is written, just like with Mr. Kuntz, with the presumption that the parcel of property being located where it is provides certain environmental functions that's in the government interest to protect. Kuntz does require a different level. You can't just go demand a concession on a permit just because of a property's location. The government, if they're doing their job properly, is going to have to go out and look and see, say it was Mr. Kuntz's property, to see that there actually was wetland there, or that there were wetland species or vegetation, not just hobo camps and truckers.
So the responsibility would be on government to prove
Yes.
that it was what they said it was.
Yes, my name is Mark Nelson. I have a couple of questions. The first is, what consequence on the Kuntz decision do you think would have happened had Obama had an opportunity to make another Supreme Court nomination with approval from the Senate? For any of you that think that it's not important to vote in presidential elections, think again. The Kuntz decision is a direct consequence of our nation still holding a 5-4. Second, you seem to have a historical background. I've had always a great deal of respect for the attorneys at the Civic Legal Foundation. How much more onerous do these regulations have to become before our nation's citizens, who now are totally flummoxed, even by you, who stated twice, gee, I can't go there, it's too complicated. And they're expected to understand how to act with their own land? How much more onerous do you think that government regulation can become on our private property before we feel very much like our founding fathers felt when they met in little taverns with their muskets?
To answer your first question, to answer the easy question, the court is in a precarious position. It's a 5-4. There's a 5-4 divide, and this case, as you pointed out, was decided along ideological lines. If we were to lose one of the conservative justices and replace them with an Obama appointment, we would have lost Kuntz. I mean, it's as easy as that. And this is the impact of that would have been, we would have had a decision from the U.S. Supreme Court that your money is not protected by the Fifth Amendment to the U.S. Constitution. So it's more than just one person winning and losing a case.
It's confiscation of 401k plans.
It's everything to do with anything that is not real property could be appropriated without the protections of the Fifth Amendment. As to your second question, I don't think that the regulatory world needs to become more onerous before people wisen up. When I was mentioning that I was unable to comment on certain situations like involving water rights, I think that it's sort of like that joke. It's overly simplistic, but what is it? A person's a Democrat until they're mugged. That until you go through the process, until you apply to open up a new well, or to connect to a sewer, or to do a fill and grade, you're not aware. And until people become aware that the regulations don't need to become more onerous, we need to have people become more aware. And at that point, perhaps the priming of the muskets, or I would rather see the priming of the ballot box, because I can't advocate musketry from a podium. Yeah, I like blunderbusses better. That's just because they read better. I'll leave it at that.
Other questions?